My name is Zsófia Prém, and I am a PhD candidate at the University of Miskolc. My PhD research topic is fashion law with a special focus on copyright protection. So this means that today's presentation is a new research field for me, but I really wanted to address this issue because the relationship between upcycling and the fashion industry raises several legal questions. At first, I would like to talk about upcycling, but only in a nutshell, because I think almost everyone is familiar with the concept. So the practice of upcycling is based on the utilization of pre-existing materials, fabric, or fashion accessories. And it can be also defined as the process of taking something that is already manufactured and then either enhancing it or creating a new item from it in a way that increases the original's value. We can say that it has two components. The original piece that is used, which is often a leftover dead stock material or a second-hand piece, and the method by which it is transformed to increase its volume. The terms upcycling and recycling are often used synonymously, but they have distinct meanings. I have already explained what upcycling is, and in contrast, recycling is the act of transforming waste into materials that can be used to create new products. Upcycling affects two fundamental rights, the right to environmental protection and the right to intellectual property protection. Both rights are stated in the Charter of Fundamental Rights of the European Union. But this issue shouldn't be resolved by making one right more important than the other. Thus, the absolutization of one right is not the proper approach, because on the one hand, upcycling can lead to the exploitation of intellectual rights against luxury brands which are usually protected. But on the other hand, it can be a good alternative to environmental protection. So let's look at the environmental protection first. As we can hear the previous presentation, the fashion industry is one of the most polluting industries in the world, and we have all known shocking data about it. For example, clothes are responsible for between 2 and 10% of the environmental impact of the EU consumption. However, a variety of strategies have been put forth to address these concerns, such as clothing rental, circular fashion, slow fashion, and of course, upcycling as well. But while upcycling offers numerous benefits, regardless of its environmental impact, it can also trigger a lot of legal issues. Due to the lack of material caused by the COVID-19 pandemic, many luxury fashion brands repurpose leftover materials from their previous collection, which is completely legal from an intellectual property point of view. However, the legal problems start when, in the process of upcycling, someone uses a material that bears another designer's trademarks. So we arrive to the intellectual property protection. Trademarked fashion items present a challenge for reuse project in the circular economy. The protection of brand trademarks on fashion pieces can make it harder to achieve environmental sustainability. Because the more parts of a fashion item that are protected by trademarks, the more legal issues can arise. Sustainable reuse could lead to claims of trademark infringement if visible logos from the original items are still present in new products made from the fashion waste or some dead stock materials. So what could be a solution? At first glance, the doctrine of exhaustion of rights is a good argument for the legality of upcycling. because in accordance with this doctrine, the right holder must allow others to distribute copies of their work, even for profit, if they have received adequate remuneration for the initial distribution. So once a trademark owner has introduced a product to the EU market, these rights are considered exhausted, and the trademark owner can no longer rely on trademark rights to control the product's future circulation. But the question may arise is, will upcycling lead to the exhaustion of trademark protection? Basically, no one knows the proper answer yet, but there are three possible answers. The first answer could be no, because the original consent to use the trademark was only for the entire product, not for the parts of it. The second approach says that it depends on whether the changes affect the product's ability to show its origin. Because if the upcycling process significantly changes the product, creating something new that can be linked to the original, the new product can be sold without infringing trademark rights. And the third approach argues that upcycling exhausts trademark rights because it transforms the product or its parts. And once changed, the original product is no longer the same as the upcycled version. And I would like to show you two case law. One of the most recent case involving upcycling was between Chanel and Shiver and Duke in the United States. Chanel filed a lawsuit for trademark infringement and unfair competition because the Chanel buttons used by Shiver and Duke were not directly from Chanel, nor did Chanel know or approve their use. These buttons originally meant for Chanel clothing, just like blazers or skirts or pants, and not for jewelry. And Chanel also claimed that Shiver and Duke's upcycled jewelry looks similar to the Chanel's own jewelry collection, as we can see it in the picture, which could confuse customers into thinking that they were buying real Chanel items. And additionally, Chanel argued that using the buttons in jewelry was different from their original purpose, so Shiver and Duke couldn't claim trademark exhaustion as a defense. And finally, in November 2022, the two parties reached to a confidential settlement. And another brand often used in upcycled products is Louis Vuitton. In 2021, Louis Vuitton sued Sandra Ling Designs because of trademark infringement as well. SLD was making handbags, accessories, and clothing from pre-owned Louis Vuitton items. These products made from deconstructed Louis Vuitton materials, but these still showed Louis Vuitton's trademark, as you can see in the pictures. And Louis Vuitton complaint stated that they had sent a letter to SLD warning that selling these items violated their intellectual property rights. And Louis Vuitton also claimed that these upside products could easily confuse customers, just like in the Chanel case. But SLD responded by saying that their products included disclaimers stating that they were not affiliated with Louis Vuitton, so the customer confusion was unlikely. And again, just like in the Chanel case, this dispute ended in a confidential settlement as well. And it can be concluded that that upcycling is currently not yet subject to a solid legal framework. The courts also give different rulings in different cases, but it is really important to achieve a balance between the competing rights, namely the right to environmental protection and the right to intellectual property protection. A possible solution could be a new labeling practice that provides full and honest information about the origin of the upcycled products. And in my opinion, last but not least, sustainability-orientated rethinking of the issue of exhaustion of rights could be an important step towards a circular economy. And thank you so much for your kind attention.